Welcome back to the Liberty Block podcast. This is a special edition with Alu and my father, Steve. We are going to be discussing the Rahimi case, United States versus Rahimi, in the Supreme Court. It was decided 8-1, and they published it on the 22nd, I believe, yesterday morning or Friday morning, 2 days ago. It's an interesting case, somewhat simple in general, upholding domestic violence restraining orders being prohibitive of having firearms, but there are a lot of reasons it's complex, and I'm going to argue with Stephen in a minute about the 1,000 reasons why it is complex and why we disagree on some stuff, maybe. Zackey Rahimi was a guy in Texas, I believe. He had an ex-girlfriend who also had the child of his, so they had a child together. She allegedly, according to her accusation and according to criminal charges against him, he was charged with the crimes of assaulting her, possibly having drugs in his house, having shooting at her and shooting at others, a few different incidents. So he was arrested and charged with all of these. At this point in time, when this case began, he was not convicted. So technically, I don't think, according to all the records and the briefs and everything, I don't think he was ever convicted of any crime ever in his life. But more specifically, regarding this case, regarding all the accusations, we have here accusations of him abusing his wife. He might have, or his ex-girlfriend. If he did, he's a bad dude. If any of the stuff is true, he's a bad dude. We just don't know if it's true. He has not been convicted. Anyway, she at some point filed a restraining order against him, being that they were romantic partners at a point and had a kid together. That means that they are cohabitating for the purpose of the state laws of the restraining orders of Texas, meaning it's a domestic violence restraining order, and we'll get back to that about why there is this distinction there with other restraining orders of the general crowd of harassment versus stalking for non-partners. Anyway, she filed it ex parte, I believe, at first, and he had a point.
Let me slow you down a minute. Number one, my understanding is these are federal restraining orders. Am I not?
No. Okay, no. So this is why one of the reasons why this video is going to take like 17 hours. It's very complicated because it's a very awkward thing mechanically. There's no such thing as a federal restraining order, I don't think, unless you're talking about people who live on a reservation or a federal land or a federal.
So the restraining order,
what it is,
state, but the law that prohibits firearms.
Exactly. So there's some redundancy because every state, all 50 states have restraining order laws, obviously, and then some are different. Every state has their own police powers of the state government system. So in Texas, he went to a Texas court. He went to a court, applied. Probably the first restraining order in Texas, as per Texas law, under Texas statutes, is ex parte, which is Latin for without one of the parties there, meaning he does not know about it. The plaintiff, this ex-girlfriend in this case, filed a restraining order. He was served a notice saying you cannot go close to her, you can't, contact her, abuse her. And then generally within a month or a few days, depending on the state law here, I think it was 10 days, they give him a chance to represent himself in an actual hearing, because the first temporary restraining order, most states call it, he doesn't have a chance to defend it. The judge listens to the plaintiff, and they practically always approve it. In my experience, about 100% of the time, they approve that restraining order based on they make an accusation, and the judge believes her. So she said he abused me. Anyway, he got an opportunity, according to the record, he had an opportunity to defend himself at the subsequent hearing to see if the restraining order would last for a full year or 2 years in Texas, I believe. It doesn't say whether he went to the hearing and defended himself or agreed or didn't go to the hearing at all. It just says he had an opportunity to attend the hearing. That's one of my 20 issues that I listed in the article that I have with this entire very long 100-page decision. Nobody mentions whether he actually attended the hearing. And anyway, so stop me if I'm going crazy or all over the place too much. So what makes it awkward is there's a state law in Texas, and every state has restraining orders, that says there's a restraining order, and in the statute it says, those subject to a restraining order cannot contact or abuse or message the person, can't go within a certain amount of feet of them, could be 100 feet or 1,000 feet. Now there's a federal law that just says, and this is 18 U.S.C. section 922G8, and it says anyone subject to a domestic violence restraining order, and such order was issued after notice and after opportunity for both parties to be heard. And the order specifically says you are prohibited from abusing your former domestic partner. Anyone subject to that cannot possess a firearm. Nobody can sell a firearm. It's a crime if you do it. If you own the firearm, it's a crime for the actual person. So that's a federal law. but it's one of the cases that where I don't think it's very common, where it's a federal law that is kind of predicated upon a state law. Does that make sense?
That's
Federal
not a
law,
bad
if you have a restraining
explanation.
order,
So
yeah,
basically, the important part is that a restraining order needs no criminal charges, needs no criminal convictions. It's purely preventative. If I threaten somebody and I've never harmed anyone in my life, there could be a restraining order against me on which is piggybacked a federal law saying I can no longer possess firearms. And as we'll talk about in a few minutes, that means I can't own them, I can't have them on my property, and according to some rulings, apparently I can't pick one up for 2 seconds to look at it. So
definitely not.
unlike most, the way we look at laws means you committed a crime and were convicted of something and then you lose your rights. Here you're going to be losing your rights based only on an allegation. And even the hearing, which is not ex parte, the one that followed the ex parte hearing, where you ostensibly can defend yourself, you don't have the protection of beyond a reasonable doubt that you're a threat to this person. It's more of a preponderance of evidence, or maybe
Yep,
a
and to clarify
51%.
that, what does that mean? So in any criminal conviction, misdemeanor, felony, anything in the United States and maybe all Western civilized countries, in order to be convicted of a crime in a court, either the judge or if it's a jury trial, the jury has to find you guilty, believe that the facts and evidence shows that you committed a crime beyond a reasonable doubt. So it's a very high standard. Some might say 95% sure that you did it. Whereas in this restraining order proceeding, which is called a civil kind of proceeding, that burden of proof, the evidentiary burden or standard of proof, is way lower. It's called preponderance of evidence, which is legalese for anything greater than 50%. So more likely than not. So if you think that there's a 51% chance something happened, then that is what the judge is using in their mind to either approve or not approve that order. So it's a far lower standard.
And men who are more often than not the victims of these restraining orders, or the ones restrained by these orders, will say that even if it's not 51%, judges are very not amenable, even if it's more like 40%, to saying, well, we're going to let you have your guns back. They're going to rather...
They err on the side of caution. They certainly
very much going to err on the side of caution. Exactly. So
now another
you have here
another very important issue.
Restraining somebody's rights without a full trial, and then piggybacked on that a federal law that if you violate, you can go to jail for many, many years.
Now it's probably worth noting here that state laws, I mean, in my experience, I think every state except Kansas, the other 49 states have in their restraining order either on the state laws, either automatic or up to the judge's discretion to also prohibit from having firearms. In New Hampshire, it's judge's discretion. It seems to be standard, whatever standard means. Pretty much every judge, I think, any restraining order for any reason, the judge will also check off the box saying the subject of the restraining order, they call it a defendant in New Hampshire. It could be called a respondent or whatever in different states. That person can't have firearms. So some states have that. Every state, Texas, I'm sure has, I would suppose Texas has in their statutes that the judge has discretion to either, specifically it says in the laws, he has discretion to prevent the person from having firearms, or it'll say, like a lot of states I've looked at the laws of almost every state at this point for a restraining order. Some states say the judge can do this and that and restrain you from talking to the petitioner and all that stuff, and also any other orders that the judge deems necessary or required for the safety of the petitioner. So,
okay. But aren't I correct that even if that's not in the state law, you're federally prohibited from owning weapons?
Exactly. So the way I would, after studying this for a few days, and I have to correct myself because I was wrong at first, the federal law only prevents people with restraining orders from having firearms if it fulfills a few conditions of you actually had an opportunity to be heard. So this does not include the ex parte orders, which is the initial order in almost every state, and it doesn't apply to the orders that are not domestic violence, meaning domestic people who live together. And it only applies to those where seemingly the judge specifically made a finding that you are a threat and dangerous and barred you from abusing the plaintiff, which, again, I don't know if it means like in the writing, the narrative of the order, the judge has to say that, or it's natural, because that's inherent in every order, isn't it? every order the judge is saying you're dangerous.
Okay. So all I'm saying is in the vast majority of cases, if somebody does have a restraining order extended at a hearing where the respondent slash defendant is present, then in almost all cases, it's federal law will kick in. That's all I'm saying.
Yeah, you could say that, but also there's a state law that's redundant, I believe, that would also prevent you from having firearms. In most cases, I think. But in this case, I don't think he was. Anyway, so after these charges, so he had criminal charges, he had a restraining order. It's unclear whether he knew the restraining order barred him from having firearms, and I'll explain that in a minute. And then after this all happened, before he was convicted of the crimes, police found him with firearms, and they charged him, which is very rare. Apparently, there are like under a dozen prosecutions per year of the federal side prohibition of 922G8 of possessing a firearm while having a domestic violence restraining order. Very, very few. For some reason, I don't know the background. The federal government arrested him on this federal charge for possessing a firearm while having a restraining order. He was convicted. Then, because of Bruen, the case went up.
Okay, let's go really quickly back on the laws that allow us to have firearms. A, obviously, is the Second Amendment, which says the right to bear arms shall not be infringed. And what happened was 10 plus years ago already, the decision of the Supreme Court known as Heller, which finally said this is a right that each individual holds. It's nothing to do with militias. Second Amendment guarantees the right of all people to own a weapon. So right away, the restraining order seems to take away that right. Then only a couple years ago, there was another Supreme Court decision that defined under which conditions can you be stripped of the right given in the Second Amendment. And what Bruen basically said, and it turned a whole bunch of history on its head, and said the new test that for a law to be able to stop you from owning firearms, it has to be based on history of America banning firearms. If we can go back 200 years and say, in a similar situation, during a similar dangerous situation, firearms were banned, we can ban them. If we can't find such a case, we can't ban them. On the basis of Heller and Bruen, Rahimi appealed, and the Fifth Circuit, which is the federal courts right below the Supreme Court, agreed with him and said, historically, it doesn't hold water. Historically, people were not banned from owning any firearm because of a restraining order. Therefore, this goes against the Second Amendment, and they threw his conviction out. That was an appeal to the Supreme Court. They're the ones who ruled.
The government appealed. The federal government appealed the Supreme Court.
And the Supreme Court ruled 8-1, overturning the Fifth Circuit, and they got 8 judges to say that we can prove that in similar situations of danger, the government came up with similar solutions close enough to say that confiscating all firearms is okay and doesn't go against the Second Amendment. The only justice that opposed that decision was Clarence Thomas, and a lot of what we'll cover were his objections to that decision and our bewilderment how no other judges agreed with him on this.
Yeah, and I'll admit that I technically made a mistake, which happens once every decade or so. I wrote up a whole article and did the first iteration of this video on my own last night, and it was very long. I spent hours, and then I guess I didn't read Thomas's full dissent, the one judge who disagreed, because he apparently covered most of what I covered. But I thought I was a genius for saying, look at all the issues with the majority opinion. But apparently Thomas also covered most of the issues I have, because I have a lot of issues, and we'll get into them. So where do I even start? I want to start with the presumption of innocence and guilt and alleged, and not using the word alleged, which is an issue I think the majority has. Nobody says alleged until Thomas. There's the burden of proof. Nobody mentions that restraining orders are lower than beyond a reasonable doubt in criminal convictions. There's that. And then there's attacking, like Thomas also attacks the historical analog type of issues they have, and a few other things that I just noticed. So where do you want to start, or do you want to do a question and answer thing?
Well, since I don't want to spend too much time on it, let's just say briefly that the 8 justices, and I did not read all the concurring opinions, but the major decision was by Chief Justice Roberts. They said if we go back in history at a time when people were considered dangerous, the government had 2 different paths through which it could ban owning weapons, or it could somehow restrict owning weapons. One of those things was what they call surety laws, which I understand kind of like bonds. So if someone was considered dangerous or threatening to the public or to his spouse or domestic partner, he would have to put up a certain amount of money. And if he would then do something to break the law, he would forfeit that money. So he could keep his weapons, but he put up a bond against the fact that he wouldn't use them aggressively. And the second set of laws were based on, what do they call, arrays? Is that what they're called?
Well, affrays were the old word for
Affrays,
public fighting,
right.
but they were called going armed laws.
Right. Okay. So they use that also to say that, see, where there is a issue of dangerousness, even in the future, even not based on something horrible that someone did in the past, they had these other laws which banned ownership and possession of weapons. Now, as Alu pointed out very well in the article he wrote and a previous video, much of the evidence, so to speak, that the Supreme Court was using to say we can take away these weapons was based on laws that predated America and its Constitution. And as Justice Thomas,
and that would be thrown out today under scrutiny of today's Constitution. So don't you feel like a circular logic saying, like, in the 1600s, England had this, therefore it's okay that the English government had it in the 1700s all the way back to the 1300s for some of these laws that they
right,
cite?
because what they're trying to say is that proves that it's historically part of the Second Amendment, and since we have to find something in history, we'll just go back to history even before and sort of assert / pretend that those laws survived the Constitution. It's Justice Thomas who points out that sounds really neat, but the Constitution was specifically written against those ideas. The Second Amendment specifically overruled all of those historical precedents. Yes, sir.
Yeah. Well, a few things. Number one, we literally fought a war. Didn't our forefathers fight a war to get away from England because there was not enough liberty? So to cite something, and I don't understand the William Blackstone citing, Blackstone who wrote about the treatises of government and democracy and stuff in the 1700s, but him writing about English law as precedent and saying that because English law has to reign, how do you cite English law when we fought against them and said we're ditching our laws?
So, not playing a lawyer on TV, what I will say is things not directly opposed by the Constitution. It makes some sense to say that a lot of English law was inherited by America for business kind of laws and those kind of things. Thomas's argument, which is what the argument we made, is this was specifically opposed by the Constitution.
Yeah. Anyway, my bigger issue that I was going to say before I forget is the surety bonds. It's like a collateral type of thing, like a bond, kind of like if you're familiar with being bailed out of jail. When you bail, you can use a bond or use anything like collateral. You can put up your house or money, and you put that money in for the court to assure that you come to court for your hearing, your arraignment, and your whole trial. And if you flee, you don't show up, then they keep that money. So it's a collateral kind of thing. How is that an analog that is very, very far? I just realized it's very far from the current law or restraining orders where they take your guns, because Thomas mentioned that it's similar, and I said in my article that it's very similar to restraining orders. It's not. Surety laws, they're saying put up a bond, give us a little bit of money as collateral. I would rather put up a little money as collateral to say I won't, commit any massive crimes like murder in the future, because I know I won't, than have my guns confiscated.
Well, that is what
or
Thomas
those
argues.
Analogous.
Thomas
okay,
says
he mentioned
not,
that too?
He does. He says it's not at all analogous. How can you compare putting up money against behavior to losing your weapons? And Thomas even makes the great argument. He goes, how ridiculous this is. Somebody can have a restraining order in South Florida, move to Seattle where he'll never, ever come into contact with this person again. He moved to Seattle so that he won't have to be in contact, and he still loses all his rights. He goes, how can you compare that to a surety bond? So, yes, he has great arguments to say this is nothing like the surety bond. He tosses away all of the pre-constitutional laws and norms because the Second Amendment could have included those. Since the Second Amendment specifically didn't include any of those situations, it didn't say the right of the peaceable, and he specifically uses that word, the right of the peaceable people to bear arms, or the right of the responsible people to bear arms. Therefore, we don't care if responsible and peaceable appeared in Blackstone or any other English common law type of places, which is what I love about his argument, and kind of weird that none of the other justices wanted to see it that way. They seemingly expanded how close do things have to be analogous. They were not very tight, and Thomas, in his dissent, even brings proof of why the analogs need to be tighter and need to be closer. He said this is totally not consistent with other court rulings to say a surety bond of, okay, I'll put $10,000 in the bank that I won't do something, is very different than losing all of your weapons, not being able to buy any more weapons, and not being able to basically handle any more weapons, which totally implicates the Second Amendment, which a surety bond in no way does. Now, the other thing
was going armed.
I'm sorry?
The going armed was the other historical analog that the majority attempts to use.
Right, they phrase things.
You save it. Now, so what was the going armed law saying? If somebody menaced others with firearms, meaning threatened somebody with a firearm, so we could safely assume using a gun to threaten someone or actually shooting at them, then after that, they could be prevented from going armed, which was a historical term in, I think, the 17 and 1800s, prevented from seemingly open carrying or using guns in irresponsible ways. It doesn't make it clear whether it's a total confiscation or prohibition on firearms. It says you can't carry in public, or it's not really clear. But anyway, this is after somebody has menaced others with firearms, and that's a quote. Punishing those who had menaced others with firearms. That's the quote. Would it be appropriate for me to say we could safely assume it says they committed a crime? That means they're convicted of a crime in a criminal court? They were convicted of menacing?
I don't have to say that, even if they were convicted. My understanding of those going to arms situations, just from reading the rulings here, is we're talking about a guy who gets on a horse, rides through town shooting his guns willy-nilly. And now we say, wait a minute, you are totally irresponsible. You've shown your intentions are not responsible, are not peaceable, and we're going to restrict somewhat your ability to do some things with your weapons. It's not
but it seems clear that he could still have weapons in his house and not be a soft target sitting duck.
That's my understanding. I can't swear to that being true.
Whereas Rahimi and people with restraining orders can't have any firearms ever in their house.
Much more restrictive, and that's why Thomas says you absolutely can't find a historical precedent in those laws to taking away someone's guns, and then especially like we're talking about if they move across the country. So, and the other point, because I don't want this to be a very long video, is Thomas at least mentions the due process issue, which we lay folks understand, as we said before. If you were charged with a crime, went through real defense, had a jury convict you, that's due process. But in these restraining order cases, nobody's arguing that you get that type of a due process. And the answer of the other 8 judges to Thomas's argument seems to be, well, no one brought that up in the appeal, therefore we're going to ignore that and not address it. And my understanding is that if you pay a couple $100,000 and go to law school, that makes sense. To me, who didn't go to law school, I have an issue with that. I was saying, well, if you would have brought up due process, you may have won your case, but since you didn't bother putting those 2 words, even though they're in the Constitution, then we can't address that.
Yeah, I'm not sure. I can't say for sure. I think the Supreme Court justices can do what they want. They can nullify a law for reasons like a constitutional reason, Fifth Amendment due process clause. I would assume they could do that.
Excuse me. Are you saying that a Supreme Court justice could invalidate a law based on one clause in the Constitution, but then go back and rewrite the law and say Congress really meant it to be based on another clause, and therefore.
Well, that was Roberts, wasn't it?
I know you're not going to say a justice could do that.
Yeah.
He could actually call a fine a tax. So yes, could they do it? Yes. Do they have to? Apparently not. And again, not being a lawyer, I've always had trouble understanding, well, you didn't raise it, therefore we don't care about it.
And about raising it initially, so what we're getting at, it, for those who don't understand, is when this originally happened, so this was a federal charge, so unlike most criminal charges on the state level by the state government, this was a federal charge, so it was right away in the federal court. The trial court is called the district court, somewhere in Texas. The person, so Rahimi was not very wealthy. He was assigned a public defender, the lawyer who works for the government who defends anyone who can't afford one. And this lawyer, who it does seem like he was pretty decent because it seems like he was the one who argued the case all the way up to the Supreme Court. But he apparently did not mention when he fought the charge, he was defending him against the charge of 922G8 for possessing a firearm with a restraining order. He did not bring up a due process violation issue. He only brought up the Second Amendment in his defense. And then they challenged the law. They said on its face, the whole law, 922G8, is unlawful because the Second Amendment conflicts with it, and the Constitution is higher than a federal law, and therefore we have to nullify the law. They didn't bring up due process. I don't know why. That is a mistake. So I said a second ago he's a good lawyer, but that is a pretty.
It seems to us it's a mistake. I mean, you touched on an issue I really don't want to go into because it's much more in the thick of things, and I don't totally understand it. That he challenged the law facially, and apparently for the government to counter that, all they had to do was say there could be one case ever in the history of the universe where this law does make sense. Therefore, we're going to keep the law. He could have challenged it a different way. Again, that's getting really, really into the thick of things and a whole bunch of legalese. But I think you're right. Had the court wanted to throw due process in there, they probably could have. But again, to the cynics who aren't lawyers, it sounded like they didn't want to go there. They didn't want Rahimi, who was a bad test case. They didn't want him to get his guns back, right? So rather than saying on due process grounds. Now, obviously, he didn't lose the guns on due process grounds. Thomas's challenge was he lost the restraining order without real due process. And then all of a sudden, you can be convicted of a felony based on an underlying crime for which you never really had due process, which again, to us non-lawyers, sounds like a raw deal.
Yeah, and again, sorry, but there are so many more issues. It'll be another 15 hours to keep you on the line because one more quick thing is the federal law 922G8 says that this does not apply to police officers. So a police officer can abuse someone. He can abuse his wife, beat his wife, shoot at his wife. And if she gets a restraining order, and if everyone agrees, and if he agrees that he did shoot at her, and there's a restraining order in place, he can still have his guns. So one day I'll chat with a lawyer who will argue with me about that being a violation of the 14th Amendment's Equal Protection Clause, where all the laws were supposed to be equal under the law, yet police officers can literally, after a hearing, be found to be abusive to the wives and still have guns, whereas the rest of us can't.
That's another argument for another day because equal protection may only apply to equal people, and obviously some people, would we say the same thing about a military person? Or do they have any special need or right? So even though I totally agree with you, I could see people making arguments the other way.
Yeah. So my next massive complaint is the alleged thing. We all know, again, us being in the media for like 7 years now, we know that you cannot, if someone's not convicted of a crime, you cannot call them a criminal in that sense. If they were charged with abuse, suspected of abuse, someone accused them, if they were not convicted yet, you cannot call them an abuser. You have to say they were suspected or accused or they're an alleged abuser. You'd think that literally the highest judges in the world, the Supreme Court justices, would know this. How is it that the word allege, the whole root word allege, allegedly, alleged, does not appear anywhere in the entire decision until Thomas's dissent? Am I crazy, or did the justices commit defamation when they called him an abuser?
Do justices also use alleged?
They should, and Thomas does. Everyone should. This is for media and judges and everyone else. Why didn't they say alleged?
I obviously I have no answer for that.
And the media, the only media I think you found, was it Politico that said alleged?
I know I saw one place that said it. Yeah.
Politico, but the rest didn't. I think a bunch of other media organizations like this one ban on domestic abusers owning guns. Rahimi was not a domestic abuser. That's a fact. Am I wrong? He's an
Well, if
alleged
he
abuser.
wasn't
He was never convicted.
convicted of being a domestic abuser, then no, he should not be considered a domestic abuser. And
Although a
again,
judge made a
that's part of what
finding
Thomas
in a
is
hearing.
saying. Right. Well, they made a finding for the purpose of extending a restraining order. And again, what Thomas is arguing is that's nice, but that finding shouldn't be enough to then evoke or invoke a federal law. There should be a higher bar to invoke that federal law. That's your argument, and that's the argument that Thomas is making. So a finding, yes, the guy got to court to defend against a restraining order. The judge heard from some people. He heard your defense. He said, you know what? We're still afraid this guy is a danger. So yes, he made a finding based on evidence. But to then convict somebody of a criminal charge based on that, that's what Thomas is very unhappy about. And that's what it's hard for me to understand why the other justices weren't just as unhappy about.
So do you agree with me that... Sorry. Do you agree with me that some of the ambiguous language is problematic, such as where Roberts writes in the opinion, the order, the restraining order he's referring to, entered with the consent of both parties. So he agreed to the restraining order saying, I'll stay away from her, it's not a problem. That order included a finding by that judge that Rahimi had committed family violence. Do you not see an issue with that like I do?
So I have to read again the exact language. Again, the finding of the judge in the restraining order doesn't have to be beyond a reasonable doubt. So yes, he made that finding based on 51% of the evidence.
But what I'm saying is the issue is that, can you see my screen? I'm sharing my screen with you.
I'm sorry?
I'm sharing my screen with you.
Okay.
Can you see this?
Yeah, it's not that big, but okay.
It says the order that was entered into with the consent of both parties. So he probably agreed to just the end result of the order. The restraining order will be in place for now. He probably said, I don't want to see that woman who I hate be word. I don't want to see her or talk to her anyway. That's what he thought to himself. And he said, okay, I'm not going to fight it. I agree with the restraining order. What he might not have agreed to was everything else that the judge was writing in the narrative of the order, saying, I made a finding of this and that and the other. This makes it seem, this implies that he agreed to all the findings. But he most likely did not.
You're making a really good point. Your point is, he may have never known at that point that if the judge also writes 2 sentences, he will then be subject to a federal law of losing his firearms. And I've had...
Well, that's another thing. He probably didn't know. He
right.
Probably almost for sure he didn't know. Even this on a state level, like on a state, if John Smith in New Hampshire gets a restraining order against him, I guarantee he does not know until he reads thoroughly the restraining order that he's also barred from having firearms. He probably thinks
he knows that from the ex parte order already.
Only if he read it thoroughly.
Well, but that's on him. When you're handed an order, you got to read it. If that says you lose your firearms, that's on him. However, what I'm saying is, even if at the hearing they make this finding that, yes, he's a danger, and we don't know what this consent means, because you're saying he consented to the restraining order. He may have even known he's going to lose his arms according to state law. But had anybody told him that now he's going to be implicated by federal law, and the reason is because the judge wrote those extra sentences in there. Because all the justices here are saying the federal law needs a declaration from the judge that he is a danger to so-and-so. So did anybody ever tell Rahimi, before you leave this courtroom, you realize you're going to be subject to a federal law taking away your firearms? Now, again, I'm not a lawyer. I'm not a criminal lawyer. My understanding is that federal prosecutions find convictions at an extremely high rate compared to state prosecutions. So that's why there would be a difference, if I'm correct about that. Did this guy understand that he's now subject to this federal law? I doubt it. I guess it's possible that a lawyer told him this at some point, but I doubt it.
And then a similar issue is I think it's ambiguous or even deceptive when the decision says, although Rahimi had an opportunity to contest the testimony, he did not do so. Does that mean he had an opportunity to go to the hearing because he got a notice in the mail, but he didn't go. So I mean, he went to the hearing. What does opportunity mean? I feel like these judges could have clarified that further.
Right. Now, it could be that we're missing something. But yes, I agree with you. As the layman reads this, what does that mean? Now, am I mistaken that in New Hampshire, the restraining order hearings are restricted in time?
All hearings, pretty much, criminal trials, everything is like restricted for 30 minutes unless otherwise,
criminal trial can go as long as it can go.
They're 30 minutes unless
6 weeks.
In New Hampshire, in my experience, everything is set for 30 minutes. And you would let the judge know or make a formal motion or something that, you have 17 witnesses and it's going to be a lot longer, and then they'll schedule a day or a few days for it. But if you don't make any motion or let them know, everything is set for 30 minutes.
Right, so my understanding, again, if somebody believes I'm wrong, they can correct me. My understanding is, because I've been to restraining order hearings, and they're not run as trials, and because the burden of proof is much lower, and the judges don't look at it as the same as throwing you in jail for 5 years of your life. They tend to say, let's get this over with quickly. I think you're dangerous. I'm going to extend this for the rest of the year. You want to bring 2 witnesses, that's fine, but that's it. It's not this open-ended, you get a full defense, which can take weeks and weeks and weeks of trials, which has discovery back and forth, which has so many other processes that go on in criminal trials. So I don't think judges take these hearings like criminal trials. They're more, let's get this off my docket as fast as I can. So again, that's kind of what Thomas is complaining. But then based on that hearing, you are now subject to federal felonies.
Yeah. Another issue that I brought up in the article, I'm going to read the full decision more thoroughly to make sure I'm not mistaken, but it seems like they start off, like in the early part of the whole decision, the court says that Rahimi, shot this person, shot that person, did this, beat his wife, was found with drugs and guns. It doesn't seem, again, this, I don't know what the average, the typical Supreme Court decision says, but generally there's a source. It'll say according to the record, which record doesn't mean much, but it says according to the record. That's how judges talk. I guess it means by the briefs of both sides, or according to a conviction or a probable cause, warrant application by a cop. It says all these things, and I think at one point it says according to the federal government's brief. So I guess, but still, that doesn't mean there's evidence for
because
it.
It could be that all this was stipulated even in the Fifth Circuit. Those may be things he's not contesting. So that's why I have to give the benefit of the doubt. He may have gone to the Fifth Circuit and said, yes, I did all these things, but you still can't take away my gun rights because of the Second Amendment, and the Fifth Circuit agreed. So that wasn't part of the argument here at all. So I get that.
Yeah, and then another big issue that you brought up and you bring up a lot is the Second Amendment is clear, so it should not be infringed, but it could be amended. An amendment to the Constitution can be amended. An amendment to the Constitution can strike that amendment, or it could alter it.
That is the point that we haven't seen in the press from the articles I've read. If it's so obvious that this is okay and this is necessary, a constitutional amendment would not be that difficult to pass if everybody indeed agreed to this. And all it would do is require a few more words that would put this federal law right in there. It would say the right of this people to bear arms shall not be infringed unless subject to restraining orders. It's a couple of extra words, and if it's so obvious, how long would it take to pass the amendment?
And if everyone supports it, then it could pass we could amend the U.S. Constitution. Now, the next issue is,
and then we would.
Can you believe that in their concurrent opinion, Kagan and Sotomayor, 2 of the progressives on the court, literally they called for means and scrutiny, and they really want to get rid of the whole Second Amendment. Seemingly, they don't believe in gun rights. They think that the government should be able to restrict any guns they want and any people they want in any way they want. And they literally said means and scrutiny. Can you explain what that means and why that's outrageous? I don't know if you're surprised or not, but I think it's outrageous.
Well, here's the deal. I don't think it's outrageous. I think they should pass a constitutional amendment and get what they want. Or I believe there's something like 185 countries where that is the rule, and that's fine too. But the Second Amendment says what it says. So if they want to change it, let them go out and fight it, in Congress and in the states. I can't read what you're highlighting. It's a little small on my screen. But
Yeah, that's all right. I mean, in that concurrence of Kagan and Sotomayor, they say it was back, the Second Amendment was ratified like 1791, right after the United States was seceded from Britain. And that's back when guns took a long time to load. They fired only one shot and often misfired. And that's a quote. And then they say, rather than asking whether present day regulation has a precise historical analog, courts applying Bruen should consider whether the challenged regulation is consistent with the principles that underpin our regulatory tradition. And being that the principle in both historical and modern laws is to ensure public safety, this is me talking now, no laws could ever violate the Second Amendment. So they're saying, don't look at the historical analog like a close law or a twin or a similar law. They say, let's look at the principle. And the principle was obviously public safety. And if that existed back then any current gun regulation is kosher. So that's an issue. But again, falsely saying that they had one shot, they often misfired, took a long time to reload. There were machine guns. We reference this and cite this very often. It was called a Tuckle gun. It was patented in the 1600s, actually. So in the 1700s, it was surely around and accessible to those who wanted it.
You did
it was
not
a machine gun. They were around.
You did not seriously think Kagan and Sotomayor were not going to stick in there their argument always that all guns are bad. I mean, come on.
I mean, I'm not super shocked, but I haven't read quite enough of the gun cases and reading their opinions. But I would assume it's probably what they would do. But it's interesting that they're quite so radical and they're kind of coming out and saying it.
I'm not the least bit surprised that they want to cash in the Second Amendment just by the Supreme Court doing so.
Didn't John Paul Stevens, the Democrat who recently retired from the court, write an op-ed a few years ago saying, yes, let's repeal the Second Amendment?
I think so. But if they want to repeal it, come out and say you want to repeal it and fight for that. That's fine. But I'm not surprised that they said that because we know they want to get rid of the Second Amendment. That's not a secret.
Okay, so I think I can't include all the points, so we'll kind of start wrapping it up here because it's been way too long already. But the other last point I would say is now that the federal government has upheld this law, now again, I'm not going to lie and say this is the sky's falling, this is the new law. That what the court did was just uphold 922G8, the restriction on firearms for these people. But now that the federal government has upheld it, very unlikely to be overturned, especially this was 8-1. Everyone, including the conservatives, except Thomas, agreed with it. This is one more reason why I think separating from the union, states like New Hampshire, Texas, California, Florida, states that support liberty or that don't like D.C., the federal government, federal politics, for some reason, one more reason to consider secession. Maybe, thanks for reminding me, I'll add it to my list of 120 plus reasons to secede. So that's one more takeaway.
The argument against that is all of those states do have restraining order laws.
Yeah, but this is a redundant thing, and some states aren't necessarily as bad, and it's easier to fix things on a state level, as you often say.
I agree with you. I totally agree with you. It's unfortunate that restraining orders have become so incredibly commonplace. Now, maybe the one good thing is 99% of Americans never heard of a surety law until now, and now 1% more have. And maybe now they should say, instead of restraining orders, let's go back to surety laws. So maybe that's a good thing, because no one ever heard of those before, right?
Yeah, I never heard that term before. So, okay, so I think that's all. And the last thing I would say is a shameless plug. I address a lot of this stuff, including restraining orders and red flag laws, in my book, The Pocket Guide to Killing Gun Control, available in Kindle audiobook and paperback formats. And Presumed Guilty, I address a whole chapter through red flag laws and due process. The whole book's about due process. And I have a whole chapter on restraining orders. So red flag laws and restraining orders, I believe.
The whole point of a restraining order is you've never been found guilty of anything. So yes, definitely read both of those books. Okay.
Okay, so any final comments? I think that covers most of my big issues, but again, you got to read the full article. Hopefully the senior editor, who is right there in the corner, the senior editor and consultant for Liberty Block, will approve my article at some point soon, and we'll publish it. And this has a lot more detail, plus the links.
And read the decisions.
Yeah, we'll link the decision.
And read the decisions. All righty. Wish everyone a wonderful evening.
Thank you so much.
Okay, Alan, I know you're going to cut it there. You did a good job.
Yep.
I got to go shopping and I got to go home.
Thanks for staying awake so late. I know.
I let it last so long, but you did a pretty good job. Thanks.
Yeah, but again, like I told you, I was right. There's a lot to talk about. We can't do it in 2 minutes. So I was right.
But if I would have been 40, it would have been 4 hours. Good night.
All right, good night. Thanks.